University. Thank you so much. Welcome PVC sir.
Good afternoon, everyone. Now, it's a great honor that Senior Advocate P.K. Sandhiji is with us. Sir, I kindly request you to please announce the result for the final.
'Semi-final team results, according to which two teams have reached the final. It is B5 from CR Law College Izar, offline. Members of the team are Amandeep Singh, Geeta, and Tanu.
Please come forward. The pupils come forward. Please give a quick round of applause.
Congratulations team. Wish you all the best for the final round also.
The second team is A4 from BRC and Behel. It's Muskan, Rakesh, and Nitish.
Please come forward. Come forward.
You are the taking things.
Congratulations team for the final rounds.
So now we can go ahead for the finals.
Go ahead. Can you please tell them the time limit?
Okay, congratulations team B4, B5 and A4. Now, I'll firstly explain the rules regarding the final rounds. Each team shall get a total of 30 minutes to present their case, and the time for the rebuttal and service is 5 minutes. Any extension of time beyond the specified period shall be subject to the discretion of the judges. The division of the time between the speakers is the discretion of the team members, subject to maximum of 15 minutes for one speaker.
Now you invite the team here on the lecture stands. Which team is coming first?
B5 team, please come forward.
Yeah.
Present your proposition for final round.
First of all, there is a draw vote. After that, we decide it's from appellate or respondent.
Draw as.
Appellate.
Right? Please, you will start.
Team B5, it's from appellate side. You have only 30 minutes. Please try to conclude within 30 minutes. मैं एक चीज क्लैरिफाई कर देती हूँ, जो अपीलेट की तरफ से हैं वो एक्यूज को डिफेंड करेंगे.
Yes. First of all, I warm welcome to our Dean sir, Dr. Ramanji sir. A big round of applause to you. And now, both teams have 10 minutes each. 10 minutes for one team, that is B5, and 10 minutes for team A4, and 5 minutes for the rebuttal. So you have to conclude the things within 10 minutes. Got it? 10 minutes to B5 and 10 minutes to A4 team and 5 minutes for the rebuttal. If you want to clarify anything, you can right now ask anything.
It's an appeal. Right. Thank you. So the appellant has the first right. Please to open.
Hello.
The appellant presents the case from the side of Mr. Vicky, who has been sentenced a rigorous imprisonment of 10 years by the High Court of the Andhra Pradesh, and the council now seeks permission to start the case with the statement of jurisdiction. May I start, sir? The appellant has approached the Honorable Supreme Court of India pursuant to the decision by the Honorable High Court of Andhra Pradesh. The court's jurisdiction is invoked under Article 134 of the Constitution of India 1950. The appellant humbly submits this memorandum in pursuance of appeal filed before this court. The appellant will act in accordance with the findings and decision of the court. Now, may I just brush up, the synopsis of the facts of the case. First of all, let's understand the background of the case. The appellant, Mr. Vicky, was aged 17 when this incident happened, and Miss Eliza was aged 19 when the victim of the concerned case, which was State of Andhra Pradesh versus Mr. Vicky. They both studied at Howard High School, and they were good friends. But earlier, 6 months earlier, they got into a heated argument and they parted their ways. The incident took place on January 14th when Miss Eliza, on her social media platform account on Hacker, she received some explicit and vile images of herself, and she informed her parents, and the FIR was filed in the Mani police station on the same day. The lower and subordinate courts and the higher courts convicted the appellant under sections 354A, 354D, 509 of IPC, and section 66C and 66E of the ITR, imposing a 10-year sentence for rigorous imprisonment. Now, I would like to start with the arguments. First of all, the issue number one, whether Mr. Vicky can be held liable for cyberbullying and harassment endured by Eliza. It is most respectfully submitted by the council to the Honorable Court that the concerned incident, which happened on January 14, when the incident was indeed derogatory and it traumatized the victim. But the main question here lies is whether Mr. Vicky should be liable for the harassment and cyberbullying endured by Eliza or not. First of all, I would like to present reference P1. Is a definition of phishing attack according to the IBM Tech Brands website, in which it states that successful phishing attack can often lead to identity theft, credit card fraud, ransomware attacks, data breaches, and huge financial losses for individuals and corporations. The contentions of the respondents, which were in the earlier cases, was that the information was only available to Mr. Vicky, But the main thing is that the information which was available to Mr. Vicky only was now available to the hacker also. So he used those information and created the maliciously explicit images and sent to Miss Eliza. Now I would like to continue with the issue number 2. Whether the age of Mr. Vicky warrants special consideration for him and should he be treated as a juvenile in this legal proceedings or adult. It is humbly submitted that the appellant should not be treated as an adult because he did not commit any heinous crime, and the definition of which is mentioned in section 2, clause 33 of the Juvenile Justice Act 2005 15. Sorry. The provision is there that we can treat a person from 16 years to 18 years as an adult, but if he has committed only a heinous crime, in which the imprisonment for which is more than 7 years. Also, in the case of Mukesh versus State of NCT of Delhi and others, which is popularly known as Delhi Land Rape case, case number 8. Hearing the accused, Akshay, was treated as a juvenile in conflict of law, and also I would like to show a clipping of the juvenile on 28th January 2013, the JJB, Juvenile Justice Board, determined that Alfroz would not be tried as an adult. The petition moved by Janata Party President Subramaniam Swamy seeking the prosecution of the minor as an adult was quashed, and he was treated separately in a juvenile court. The report also mentioned that one-time grant of rupees 10,000 from the government should be sufficient to support him initially after the completion of 3 years of imprisonment, and now he's working happily as a cook in some hotel. I would like my co-counsel to start with the issue number 3 and 4.
So the issue number 3 is whether the penalty imposed on Mr. Vicky is justified and legitimate. Since appellant haven't attained the age of 18 years at the time of the incident, he needs to be seen as a child or a teenager. Therefore, the proceedings conducted against him need fall under Juvenile Justice Act, on which under Section 2 Clause 9 and 2 Clause 33, which lay the ground for differentiate heinous offence and serious offence, as well as the best interest of the child and disclosing the identity of children as it is laid down. Best interest of child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. Now, the heinous offences includes the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being enforced is imprisonment for 7 years or more. So, by the help of the definition of the heinous offences defined in Section 233 of Juvenile Justice Act, we got to know that a parent is not liable for heinous offences because there is no section defined in IPC in which the imprisonment held to be more than 7 years. Hence, according to this section, a parent should not be treated for heinous offence, and verdict given by an Honorable High Court is clearly unjustified and illegitimate. So now I would like to mention the rules, articles of the Convention on the Rights of the Child. So Article 1, for the purpose of the present convention, a child means every human being under the age of 18 years, unless the law applicable to the child majority is attained earlier. Now, Article 37 states that parties shall ensure that no child shall be subjected to torture or other savage, inhuman, or degrading treatment or punishment, nor life imprisonment without possibility of release shall be imposed for offences committed by persons below 18 years of age. Now, the UN Standard Minimum Rules for Administration of Juvenile Justice, Beijing Rules. These rules, which were adopted by the United Nations General Assembly in 1985, provide guidance on how to implement the CRC in juvenile justice system. The Beijing rules state that juvenile punishment should be the least possible necessary to achieve the desired result, and that they should be focused on rehabilitation. So in case of R versus CD, which is case number 10 mentioned in the file, a youngster pleaded guilty to arson, breach of a recognized and the possession of a weapon. He received a short sentence of 6 months of deferred custody due to the Youth Criminal Justice Act. Appeals against this case state that the youth has committed an indictable offense for which an adult would be imprisoned for a period of 2 or more years. So now I would like to quote the Nirbhaya case, which is case number 8 in the file. It's Mukesh versus State of Delhi. The 212 Delhi Aggregate is a popularly known landmark case that made changes in Indian judiciary system. So one of the accused of rape in this case was a minor. The sixth defendant's name cannot be given for some legal reason as he was 17 at that time. When he committed offense and was tried as a minor, he was found guilty on charges of rape and murder and sentenced to 3 years imprisonment in a reform facility, which is maximum sentence available to a juvenile. Now, in this honorable apex court, the case of Shilpa Mittal versus State of City of Delhi and DNR, it is case number 11. It was highlighted that offence which does not carry a minimum penalty of 7 years cannot be treated as heinous offences. However, the Act does not address the fourth category of offence. We are aware of the views expressed by us, the above court, that cannot legislate. However, if we do not deal with the issue, there would be no guidance to the juvenile justice boards to deal with children who have accomplished such offences, which definitely are serious or maybe more than serious offences, even if they are not heinous offences. So now I would like to say a few lines on doctrine of proportionality. So proportionality means that judiciary action should not be more drastic than it is ought to be for obtaining the desired result. This doctrine says that the cannon should not be used to shoot a sparrow. Thus, this doctrine tries to balance means with the ends. Now, so the sentence may be considered disproportional according to the doctrine of proportionality is concerned. Especially considering the appellant's age and mental maturity should be taken into account. But Honorable High Court sanctioned against the appellant modifying appellant as it is. There is errors in dimension being overlooked by a subordinate court in determining the proportionality of offence as the judgment was wholly based on heated argument between parties without considering the evidence of heading in support to under evidence law in section 88A. So now I would like to conclude with the prayer. So, Mr. Vicky may not be held liable for the cyberbullying and harassment endured by Aliza, and Mr. Vicky's age warrants special consideration for him under Section 15 of Juvenile Justice Act. But upon considering the aforesaid circumstances of this case, he should be regarded as juvenile only in these legal proceedings. That the penalty imposed on Mr. Vicky is unjustified and illegitimate. Appellant's fundamental right to privacy has been violated by the police in the investigation. So the investigation should be set aside on a personal ground.
Thank you so much, Team B5. Now request Team B4.
Hello.
Your Lordship Council seek permission to start with the issue number 1 from the respondent side. Much obliged, Your Lordship. Issue number 1. Whether Mr. Vicky can be held liable for cyberbullying and harassment endured by Eliza. Your Lordship, it is most humbly submitted before this honorable court. Victim Miss Eliza has endured mental pain and agony of harassment by the act of cyberbullying. Mr. Vicky's act of cyberbullying harassment has shown her inner confidence and she has suffered a significant of mental depression. Lordship, the criminal act done by her husband, her friend, created a fear in her mind, and she is broken at such level that it has negatively affected her studies. Her parents are also in shock by witnessing what their daughter has to go through. Lordship, the mental pain and harassment endured by Miss Eliza must be taken into consideration while deciding the nature of the offence. Mr. Vicky knew about the consequences of his act and he was well aware about the pain and the discomfort Eliza would have to endure. Lordship, the harassment has no limits. The victim might be drawn to serious and unfortunate consequences. Thus, the result of Vicky's pre-planned crime are serious and were known to him. Lordship, the statement of Karthikeyan, mutual friend of Miss Eliza and Vicky, must be noted here carefully. He said the friendship of Mr. Vicky and Miss Eliza was on worst stage after Miss Eliza had received an offer for undergraduate from Stephen University. The Lordship Karthikeyan also stated that Mr. Vicky has also applied for the same institution, but he did not receive any offer which leads to disagreement between them. Eliza and Vicky, the two persons who were once close friends and suddenly had an argument, they stopped talking to each other. All these incidents leads Mr. Vicky to create problems in her life and to harass Miss Eliza. Lordship, the motive behind the crime is clearly the jealousy and the frustration of Mr. Vicky after breaking ties with Miss Eliza. Lordship, the Mr. Vicky, the appellant in the instant case had liable under the following provisions, section 354A IPC, that is sexual harassment and punishment for sexual harassment, section 354D, that is stalking, section 509 IPC, that is words, gestures or act intended to insult modesty of the woman. Lordship, in the instant case, by creating malicious images of Miss Eliza, her modesty has been insulted. Section 66C of IT Act 2000, that is punishment for identity theft. Section 66E of IT Act 2000, that is punishment for violation of privacy. Lordship, in Ritu College vs. State, kindly refer page number 2 of the memorial given to you. In this case, the Delhi High Court held persistent messaging, calling and emailing by the accused constituted stalking under Section 354D of the Indian Penal Code. Lordship, the court emphasized that stalking includes online behavior that causes fear or distress to victim and is punishable under the law. Lordship, kindly refer page number 2. In Vijay Kumar vs. State of Haryana, 2010, in this case, the Supreme Court clarified that word outraging in Section 354, it does not necessarily involve physical contact and can include online act that outrage the modesty of a woman. Lordship, as per the facts of the instant case, the IP address from which the explicit and malicious images were sent to the respondent was found to be Mr. Vicky's system. Lordship, the evidences against appellant is a key factor of the case. All the facts and the circumstances pointing the finger towards Mr. Vicky as the real preparator of those images. He is the real culprit and must be liable for the harassment and pain endured by Miss Eliza. Lordship, counsel seek permission to start with issue number 2. Much obliged, Your Lordship. Issue number 2. Whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as a juvenile or adult in these legal proceedings. Your Lordship, it is most humbly submitted before this honorable court that the request by the appellant to treat the accused as a juvenile should be rejected. Your Lordship, the accused must not be treated as minor as it will a grave injustice to the victim. The accused must not let the take advantage of undue benefit of laws and provisions of Juvenile Justice Act. The cases of cyberbullying and harassment have been increasing rapidly nowadays. Its consequences are dangerous for the victim and her family. Lordship, Section 50 of Juvenile Justice Act says that preliminary assessment in heinous offences by the board, in which a heinous offence alleged to have been committed by a child who has completed or is above the age of 16 years. The board shall conduct the preliminary assessment with regard to his mental and physical capacity to commit such crime, the ability to understand the consequences of the offence and the circumstances in which he allegedly commit the offence, and he may pass an order in accordance with the provisions of subsection 3 of section 18. Your Lordship, in the present case, Dr. Anish, the statement of Dr. Anish is also relevant here, which stated that Vicky was very calm and mature of his age. This statement suggests Mr. Vicky clearly knows about the nature and the consequences of his criminal act. Your Lordship, this kind of pre-planned criminal act of harassment against a woman is a serious offence As per the guidelines of Juvenile Justice Act 2015, if offender is above 16 years of age and the offence is serious in nature, the offender can be treated as an adult. Your Lordship, Dr. Anish also informed that by going through Mr. Vicky's clinical reports, he found that Mr. Vicky is short-tempered. So the statement of matured of his age must be considered relevant here, as it shows Mr. Vicky knew the consequences of his act. As per the parameters provided in the Juvenile Justice Act, Section 18, the serious and the heinous offences must be treated as an adult, not a child. Kindly refer page number 4 of the memory given to you. In Rajkumar Gupta versus State of Punjab, the Supreme Court emphasized that each case to determine whether the juvenile should be treated as an adult based on the severity of the offences. The court upheld
knowledge whether set aside on the aforesaid ground. It is most humbly submitted before this honorable court that looking in the wiki system to get evidence relevant to the case was a necessary part of investigation procedure. The investigating authorities were working without any modified intention. The content in the system of wiki could have been removed if the authorities had taken this permission. The permission taking is a time-consuming process and it could defeat the whole purpose of justice and investigation. To avoid any manipulation with evidences of the case, the authorities have very and reasonable obligation to take the desired steps. Informing Vicky about investigation of his system could have led the possible manipulation with evidences. The breach of fundamental right of privacy in investigation procedure. It is most humbly submitted before this honorable court that fundamental right to privacy provided by Article 21 of the Constitution is no absolute right. There are certain circumstances where this right can be revoked and breached up to some extent. As per the restrictions imposed on the right to privacy in circumstances such as national security, public order, morality, and prevention of the commission of crime. In the instant case, it is humbly submitted that as per the fact of the case, the system of Mr. Vicky was an important evidence of the case. His IP address was found involved in commission of crime. So the parameter of right to privacy allows investigation authorities to look into his system. So I want to conclude my case with prayer for him. Whereas in the light of the facts stated, issue raised, authority cited, and argument advanced, may this honorable court be pleased for Mr. Vicky is liable for the cyberbullying and harassment endured by Ms. Elijah. The penalty imposed on Mr. Vicky is justified and legitimate. The order of the sentence awarded to Mr. Vicky is correct and must be sustained. It is humbly requested there is no illegal breach of privacy in the instant case, and the request of appellant to set aside the investigation must be rejected, and the judgment given by the Honorable High Court should be sustained. Pass any other order, direction, or release that it may deem fit in the best interest of justice, fairness, and good conduct.
Thank you so much, Team A4. Now, our validity session and the result will be announced in the main OD. So please, all of you, this to the main auditorium. Okay, you have only 5 minutes. So please conclude.
The commission report of the learned friend said that the crime was heinous. I had already mentioned that as per section 18 of the Juvenile Justice Act, the word heinous is already defined, in which the imprisonment is 7 years or more. It is clearly mentioned, and in every of the charges which is charged against my client, whether it is the IT Act or the Indian Penal Code, section 66C, 66E of IT Act, 354B, 509, and 354A of the IPC. All these sections have the maximum imprisonment of 3 years. And
7 years.
so maximum 3 years.
354B.
Stockings. Yes, sir. So I extended up.
It's not more than it's not up to 7 years.
Yes.
You are right.
And so it was also said that the IP address of my client was tracked in the initial flow. But the very essence of hacking is that the hacker does not disclose his identity, and identity तो उसी की जाती है जो जिसके ऊपर वो hacking attack हुआ है, phishing attacks that है. And also as per Karthike's statement, he also accepted and Karthike also seconded when Mr. Vicky said that his other friends also received some unsolicited texts on the social media platforms, and Karthike also seconded on his witness. Also about the Dr. Anish, the mental health counselor of the Harvard High School. Dr. Anish did say that Vicky is mature for his age and he knew what is good and what is bad for him. But he also said in his testimony that Vicky, although is a mature person, but he's very a thoughtful person. He would not even think of harassing someone and doing such an act of cyberbullying. Also, I would like to address to a case law, case number 7 in my compendium, Salil Bali versus Union of India and another. Case number 7.
Salil Bali. Salil Bali.
It was discovered to amend the Juvenile Justice law present to deduct the or reduce the age from 18 to 16.
Time up over. You may seek permission for that. But for a few minutes only.
It was discovered to amend the juvenile justice. It was discovered to amend the juvenile justice law present to deduct the reduce the age of the 18 years to 16 years. But the Supreme Court rejected the plea and held that the juvenile justice is based on a sound principle and with compatibility with the Constitution of NCR. Also, Supreme Court asserted that the very essence of the act is to provide rehabilitative and restorative mechanisms and help the juveniles to stand again in the society. So also in the case of also as per the Article 20 Clause 3 of the Constitution, it states that the disclosure of the password is in the nature of the personal testimony, and disclosure of password would lead to self-incrimination. Also, as per the investigation protocols, the IO would always have requested the accused for the password or biometrics of the smartphone and attain the access to the computer system legally. But with the influence of Eliza's parents, who are in the were influential government servants, he just quashed that protocol and just straight away forcibly took online access of the computer system of my client.
Want to add something? Okay. 2-3 minutes.
First thing my prosecution said, heinous offense. There is appellant said, sorry. Heinous offense. There is not a single offense in this case. There are several offenses. So the sentence is provided according to the provision of several offenses, and it is a discretion of the court to provide the consecutive sentences in serious cases. So there are serious cases. There are several offenses.
Yes, tell me.
And second question of the appellant is the measure of his age. So in the instant case, the accused is tried as an adult. So he knew the consequences of his act, and the statement of Dr. Anis must be considered very notably. He is the mature of his age, he knew the consequences of his acts, and he knew the pain will be bigger and the harassment will be endured by Ms. Eliza. So, and the right to privacy. The right to privacy has restrictions according to the guidelines of the Supreme Court. There are many cases where the guideline about the right to privacy has been provided. In the Govind versus State of Madhya Pradesh, the bench dismissed the petition and held that regulation made under the provision of the Police Act has force of law and made in furtherance of the object of the Police Act to prevent the commission of crime. So the right to privacy can be restricted and breached in the to stop the commission of crime, to protect the evidences. So the right to privacy was completely breached here as per the sanction of the law. And in Mr. X versus Hospital Jet, in this case, there was conflict between two rights emanating from the right to life and personal liberty under Article 21. The right to marriage and right to health, it was decided the right to privacy is not an absolute right and can be subjective. And the purpose is to serve the larger public interest. Thank you so much.
Is nowhere mentioned in the proposition that vigorous imprisonment is given to the misdemeanor. And your lordship, 10 years of imprisonment is also relevant as per the provisions of section 33 clause 2 of the executive or the concurrent sentence.
Hello. First of all, restricting myself to my duty as a judge in this court, it was very heartening to note that both the teams have done excessively well in preparing the case as well as in putting the case. And my request is that these two girls, they were so eloquent in their speech, they were so confident. But the unfortunate part is, tomorrow they will compete for the HCS judicial examination and they will stop speaking. They will become better. That's the unfortunate part. They should be in the active litigation part. Both the teams are framed for questions. My assistance to both of you is that my brothers, my would-be colleagues, both teams are my would-be colleagues. Did you find out as to what is the date of the occurrence?
14th January.
Which year?
No year is mentioned.
When year is not mentioned, then one party is quoting that case of 2012 Nirbhaya case. It was before this 2015 Act. There the age of child was 16. Now the age of the child is 18. That makes the difference. So when you start your case, before rushing to the case law and the research, read your case once, twice, thrice, 4 times. The law will change accordingly. Because two things change thereafter. The age is increased from 16 to 18. Therefore, the prosecution of this boy as a child is legal. Once the prosecution is legal, then we enter what are the offences for which he is being prosecuted. Question number 2. He is being prosecuted for the offences which are committed by a child more than 16 years of age, less than 18 years. So whether his case is covered by 2 subclause 33. Because if you are a child, you have to be tried by a children's court. But if you are a child who has committed an offence which is heinous, then you will be tried by the regular court. Heinous offence has been defined 7 years or more. So you have to find out whether any one of these offences fall within 7 years or not. So then you will find these are not in the category of heinous offences. Therefore, the trial under 233 will not hold the ground. Therefore, while preparing of these synopses, you are researching for the case law, but you will have to find what is the heinous. And we cannot go by moralities. We cannot go by these conventions. My learned friend is saying. You must cite these conventions, but once these conventions take the part of a bare act, those conventions are there for the government to use as a policy. But once we incorporate those conventions and in our code, CRPC, Juvenile Justice Act and all, United Nations says less than 18. We had our law in class 16. So you have to interpret the law according to that. So far as your issue of right of privacy is concerned, yes, right of privacy has been given a very wide, reach by the Honorable Supreme Court, but it depends on where it is being interpreted. When it's a question of fundamental right only, which is being violated, the right of privacy has been given the widest possible. But when it amounts to some investigation, I'll ask all of you to read once. It starts with 1961 judgment, Kochi's case. There the issue was whether your handwriting can be taken or not. Signatures can be taken or not. Which amounts to self-incrimination. Since then till today, now in the CRPC also there are amendments that the court can order you to give your blood samples, the court can order you to give your handwriting. Therefore, if the system is to be analyzed by the investigating agency, the accused cannot plead that it's right of the privacy, it cannot be pleaded. At the same time, the procedure is the agency was supposed to take the help of the magistrate. Good. For asking the accused to provide that secret code, etc., and then analyze the same. Anyhow, for your information, any evidence which is even illegally collected, but if it is a piece of evidence to prove a fact or to disprove a fact, it cannot be kept out of consideration because the method by which it was collected is not. So therefore, investigation in this case is not something which we can say is such which that it is liable to be. And you may correct yourself, 10 years is never a sentence. Because 10-year sentence is not provided in any law. You are talking of 1, 2, 3, 4, 5. Total is 10 years. I am not clear. No offense provides more than 3 years. 354, 3 years. 354A, 3 years. 66, 3 years. So no offense similarly provides for 10 years. That's why I asked if it is 10 years, 233 applies. But you cannot accumulate them automatically. That this sentence is for 2 years and for 2 years and for 2 years. So it is to be cumulatively it will not comparatively unless the court passes an order that they will go.
Consequently.
So therefore it should be a clarity in that. But this is how things. This is how we learn things. And I hope all of you have a very good future. I am thankful to Dr. Goyal for providing me this opportunity. And I am feeling my confidence has increased that legal fraternity which is coming, my would-be colleagues are having the capability to surpass all of us. Best of luck.
Thank you so much, sir, for such guidance, which is invaluable for us. And now, I request that for a validity session, we have to go for our main auditorium and students will remain here only. Students will remain here only, please.